kind welcome. We have a lot of technology here, and I'm not a very technology-savvy person, so if I do something wrong, all my fault. So please accept my apology in advance, and these lovely ladies hopefully will keep me on track. I have had a fair amount of involvement in the Alzheimer Society, and have grown in my knowledge of people who have the challenges of Alzheimer's and related diseases, and to have a real appreciation for the urgency of dealing with planning matters, many of which are legal. And there's no time like the present, and I'm sure that all of you who have involvement with people who suffer from Alzheimer's and related diseases will understand the need to plan to the degree you can while the time is available to do that. What I want to do today is to take you through a number of things on a fairly high level, and as you can appreciate, there are many details you have to consider in individual cases. But I want you to understand what the options are and what the general rules are that you need to consider when we're looking at assisting somebody who perhaps you're a caregiver for or a relative of in making proper plans as they move forward through their life's journey. The first thing I want to talk about, and let me give you perhaps a little overview. I'm going to be talking firstly about people's estates. In other words, how it is that you can organize who is entitled to what you have in your estate after you die. And that will involve a discussion about two things, one of which is a will and the benefit of a will and the power of a will, and secondly, the notion of what happens if you don't have a will and what legal principles apply for that purpose. I'm then going to be discussing notions of something called an enduring power of attorney, which is another legal principle, legal product really, that will be useful for many people who are beginning to suffer from the disease. I'll also discuss advanced healthcare directives, another tool which is available to assist in that process as well. And I'll conclude by talking a little bit about the financial issues that all of us have to deal with as we move forward. And lastly, we'll talk a little bit about driving. So those are the 5 general topics that we're talking about. And I'm going to start by talking about arranging your estate. And there are slides that will follow now. And I'm not going to read directly from the slide, but you can perhaps have a look at it as it goes along. And I will talk to each slide as we change them. So there are 2 ways that any person can deal with their estate in this province and in most places in Canada and the Western world. One of which is that you can decide to have a will, which is your direction as to how it is that your assets are going to be distributed. And there are certain kinds of rules you have to follow to make that legally binding. The second way of doing it is to not have a will. And if you don't have a will, then that is going to be done for you by something called the Intestate Succession Act. And just to give you a very brief overview as to what happens if you don't have a will, it is this: that if you have a spouse and no children, then when you die, everything will go to your spouse. If you have a spouse and 1 child, and you die, 1/2 of what you have will go to your spouse, and 1/2 will go to the child. And if you have more than 1 child and a spouse, then 1/3 will go to the spouse, and 2/3 will go to the surviving children. And then there are other various combinations and permutations. If you don't have a spouse but have children, everything goes to your children to be left equally. And then there's a whole list of different relationships depending on your family situation and where things have to go. Now, as a matter of course, certainly lawyers don't recommend that you allow that to happen unless you're completely content with what the law is going to do. So what we do suggest is you consider a will so you have some control over where your estate is going to go. Let me just change slides there. Now, if you're going to have a will, what is it you have to do? I would say this to you: the first thing you really should do is go to a lawyer. And I don't say that as a means of drumming up business for lawyers, but it's just that the consequences of not having it properly done are grave. And there are many people who have done wills that they think are legally effective, but in fact they don't comply with the legal requirements in the way that they have to do. And a court will not enforce a will if it's not done properly. So there are people who will sometimes take a kit, and sometimes that can be effective, but I can tell you that I've seen some of them, and they are not up to scratch from a legal point of view. And you're much better off if you do seek legal counsel. And I can also tell you the cost of this for most lawyers is very, very small. I mean, we're talking certainly a couple $100 or $300 probably for a simple will, and that's a good investment if you wish to have a will. In order for the will to be effective, it's got to be in writing. You've got to be at least 17 years of age. And it has to be signed before two witnesses who are both present watching the person who's making the will sign at the same time. So everybody's got to be in the same room and watching what's going on. Everybody has to sign to make sure that that is properly recorded upon the will. And you also have to make sure that the person who's signing the will, and this is particularly applicable, I think, to people who are caregivers, that if you're involved in that process, to make sure that the person who's signing the will, who might have some degree of weakness in their life or their ability to make decisions, that person is not being put under undue pressure by perhaps a family member or a friend or anybody else, because that can also make the will legally ineffective. That person who's making the will has got to you've got to be certain that person is doing it of their own free will, their own volition. And lastly, and from the point of view of people who are beginning the Alzheimer's journey, there's the question of capacity. We'll now move to the next slide. Now, capacity is a complicated thing, and it's different really for all people. What it means at its core is that the person understands the nature and quality of what they're doing when they sign the will or do some other legal act. In other words, the person has to know and understand in their own mind what it is they're doing and why they're doing it when they do it. There are three tests that I have included in the slide, which give you some flavor for the sorts of considerations that you have to have when you are considering whether somebody has capacity to sign a will or other legal document. The first one is just the general one that the person has got to understand what they're doing. So, they should be able to have a conversation about and articulate what it is that they are now doing and why they're doing it. The second one is a question of memory, that they actually understand what they have and what they want to do with it and how they want to do with what they want to do. In other words, who's going to go to, how much do I have, how much of my money, how much of my property is going to some individual. And they have to understand that if they're giving it to somebody, whatever they have, or some buddies, then they may not be giving it to somebody else. So it's important that they understand and consider, I guess, all of their family, perhaps, to make sure that they're not going to equally give their assets. They understand that they're leaving somebody out, which perhaps they didn't intend to do, but just hadn't thought about it. So those are the sorts of questions that a lawyer will actually ask of an individual when they're preparing a will, and that's an important function that lawyers do provide, is to have sort of that kind of conversation to make sure the lawyer believes that person has capacity to do the will, and that gives a greater assurance that it's not going to be challenged down the road by somebody who may feel ill done by when the will is brought forward at the time of the person's death. So sometimes it also is necessary to get a doctor involved in that process as well, and you may have to get a doctor's opinion as to whether the individual has that capacity, has the ability to understand, to remember, and to make decisions. So it's too late, really, if that exercise hasn't been gone through at the time the will is made, because then there will be no proof if it's challenged later on. So if there is any question, it's important to have professionals involved in it and to have records of the judgments of those professionals. And it's something that lawyers will do and doctors will do as well when they're called upon in those circumstances. Now, as well, the date is an important thing in the will. And the reason it's important is that you can really only have one will. So there are many cases where people will have executed more than one will over time. There can be a question as to which one is going to be effective. So if you're going to have a properly prepared will, then there should be a date on it, which is the date it was executed, and then you can compare that date to the date of perhaps an earlier will to make sure that that is the one that is going to be put forward as being legally effective. In the will, you ought to consider who your executor is going to be. And the executor is the person who has legal responsibility after you die or the person who's made the will dies, to make sure that the intention under the will is properly applied. In other words, the debts get paid, funeral gets paid for, and then whatever is left over goes to the people who are named in the will as being the beneficiaries. That person will also have to file tax returns and file certain documents with the court to allow it to be what's called admitted to probate, which is just the approval by a court of that will as being a valid will. So that person has responsibilities, and that person, although this doesn't always happen, that person is entitled to be paid a certain proportion of the estate for the duties and time they are putting into the probate of the estate.
Excuse me, Brad?
Yes.
Sorry, just to interrupt for a minute. It's come to my attention that there may be a few pages missing from the presentation or the copy of the presentation which participants have right now.
Okay.
So I just want to let them know that we will fix that at the end of the presentation to ensure that you all do receive the material which Brad is going over here now. Okay. So I just wanted to clear that up before you proceeded.
Now,
And you're ready.
There are specific things, in addition to appointing an executor and making sure it's properly dated, that you will have to consider, or an individual making a will has to consider. One of them is the question of guardianship. And for legal purposes, particularly for people who have younger children or disabled children, one consideration is, well, who's going to take care of my children after I die? And it used to be that there was no ability to name a person in a will and make it legally effective for the care of your children. So that was a function of the court. And it does remain so, generally speaking. However, for a period of about 6 months after your death, you can name an individual who will have power to care for your children until the court makes a decision as to who's going to have custody if there is no surviving parent. So it is a wise thing to consider if you are of an age where there are children involved, or you happen to have a disabled child who requires care, to name a person who you trust, who may end up ultimately caring for the child through the rest of their childhood, or have responsibility for a disabled child after that point in time. But that's only for a limited period of time, about 6 months. Perhaps the most important thing that you want to do in a will is to make sure that you deal with all of your property. So you may want to record in the will what property you have. You've got bank accounts, you've got a house, you've got a cottage, you might have family heirlooms or things which are important to your family. So in general, it's recommended that you make a list of those things and you consider if there are particular individuals you want to have a piece of jewelry, for example, a piece of artwork, or something which is important in a family sense. And if you want to give a particular property to somebody, or a combination of people, perhaps you want to leave the summer home to your children, that kind of thing, or the family home to your children, then you should say that specifically. There will then be, and those people are all, by the way, called beneficiaries of the estate. There will then be what's called a residual beneficiary, and that, or beneficiaries, that's who will get whatever you don't mention specifically in the will. So if you said, look, I've got this bank account, this house, and this painting, and you specifically say this is where it's going to go, well, anything that's left over will then be split between the residual beneficiaries, often the children in a family, but it could be other people, and you need to be clear in stating who that beneficiary or beneficiaries will be.